Excellent. Well, we have 4 o'clock Pacific time, and that's 6 o'clock Central Standard Time, 7 on the East Coast. We are going to get started. This meeting is being recorded for the benefit of your classmates who aren't here. Welcome to Contracts. I'm going to be your instructor for the next 5.5 weeks. Are you excited about this class, Christy?
I apologize, I'm eating, but yes, I am because I work for an intellectual property attorney and he does a lot with um work agreements. And so yes, I am very excited to learn more about
Excellent.
contracts.
Excellent. Good. Keep eating. Keep eating. Valerie, are you excited about the course?
Yes, very excited. I'm a newer student to the paralegal program, so this would be my third term. And so I'm just excited to get into it and get familiar.
Excellent. Well, I'll give you a brief introduction to myself. I posted my introduction in the student lounge, and hopefully sometime this week, all 22 of you students in this course will post an introduction to the student lounge. I'm Catherine Dubb. This is my 23rd, 24th year teaching. I started teaching in 1998, which was the last century. It was actually the last millennium. Seems like a long time ago. So I've been teaching law for quite some time. I got my bachelor's degree in philosophy and political science. And I had a legal studies minor. So when I was in college, I started studying the law, and I took business law and constitutional law. So I have been looking and considering legal principles for quite some time. I went to law school in 1995, graduated in 98 with my Juris Doctor degree, and started practicing law out west in California. So I do have some experience working with contracts, and I think this is an excellent course to prepare you as paralegals for your paralegal certificate, the tests that you'll need to take, and for your future career as paralegals and then lawyers. So I think you're going to really enjoy this class. Let's get started. What is a contract? Well, a contract is a promise or set of promises for the breach of which the law gives a remedy, or the performance of which the law in some way recognizes as a duty. Who are the parties to a contract? Well, there's two parties to a contract. One is the offeror. That's the person who is making the offer to enter into a contract. The offeree is the party to whom the offer is being made. One of the first things that you want to learn as you study the law and legal principles is the elements that make up that legal principle. So there are three elements to a valid contract. The first is offer, which is a manifestation of an intent to be contractually bound in specific and definite terms. The next part is acceptance, which is a promise or an act of a party indicating a willingness to be contractually bound by the terms of the offer. And last but not least is consideration, which is anything of legal value that is bargained for. Usually consideration is the subject matter of the contract. So if I promise to sell Christy my boat for $10,000, the consideration is the boat and the money. The offer would be me expressing my intent to sell my boat. And if Christy accepted that offer on the same terms, that would be an acceptance, which would indicate her willingness to be contractually bound by the terms of the offer. Any questions about the elements of a contract, Valerie or Christy? Great. Contracts can be oral. They do not have to be in writing. Why? Our legal principles came from England. So when they were brought over by England, we simply adopted those principles and called it the common law, which is common to all. At common law, contracts can be written or oral. An example of an oral contract would be Anne talks to her neighbor's son, Bob, and asks Bob if he will mow her lawn for $20. Bob doesn't have to do anything or say anything. He can simply put gas in the lawnmower, push it over to Ann's house, and start mowing her lawn. That would be considered a unilateral oral contract because one person exchanges a promise, the other person renders performance. That's why it's called unilateral, one promise. Like a unicorn has one thing sticking out of its head. So a unilateral contract is one where there's one promise. A bilateral contract has two promises. If Bob said, I promise to mow your lawn tomorrow, and Ann says, well, I promise to pay you $20 when you're done, that'd be a bilateral contract because one promise is exchanged for another promise. So, Valerie, has a contract been formed if Bob agrees to mow Ann's lawn, but they don't have anything in writing?
Yes.
Good. A common law, oral contracts are enforceable. Now, there may be a reason why you would want a contract in writing, like a lease. Why do you think you would want to have a lease in writing, Valerie?
The like the price or the offer of the part of the contract, you know, um if it's not written down, it could be like a he said, she said type of thing.
Yes. I mean, something like a contract concerning real property usually needs to be in writing to satisfy the statute of frauds, which we'll learn about in a few weeks. But land is rare, so anytime we're talking about selling or leasing land, we want to have that contract in writing. We also need to know the terms. Otherwise, how would you know how long to stay in your apartment? How would you know how long to pay your rent if that wasn't in writing? Excuse me. And the terms of eviction, all of that needs to be spelled out. So there are times when having a written contract would be advisable. Okay, let me have you read this slide for me, Valerie.
The basics of a contract offer. A complete legal offer contains 1, a promise of future performance, 2, a description of what each side gets, 3, a way to determine when each side has to perform. So
Good.
like a time frame.
Yes. So we're breaking down the elements of a contract. Again, the three elements of a contract are offer, acceptance, and consideration. What are the elements of an offer? Well, a complete legal offer has a promise of future performance, a description of the consideration each side gets, whether it be the boat, the money, selling a textbook, and a way to determine when each side has to perform, which the law will imply a reasonable time. So we had a contract for me to buy your your torts textbook, Valerie. How soon would I need to come to your house and pick up the book?
So if we had discussed the terms,
Yes.
I suppose a week.
Yeah, a reasonable time. If I waited until next year, if I waited until 2024 and I
Right.
showed up at your door saying, "Where's your book?" You'd be like, "I already sold it to somebody else." The court would say that that offer lapsed, it expired because I didn't accept it in a reasonable time or I didn't perform within a reasonable time. So the offer might have a time frame in it to tell people when to perform. You need to show up at my house next Friday with $100, and then I'll buy your stereo, something like that. If the contract or the offer does not state a time frame, then the law will imply reasonable time frame, which means if I wait 10 years from now and track you down and say, I'm ready to buy your book, what do you think a judge is going to say if I try to enforce that contract?
It wouldn't be reasonable to expect the book to be there to 10
Yes,
years later or even a year.
exactly. Okay. Enforceable contracts. Let's talk about those. If the offer is accepted, it immediately becomes a contract that's enforceable in court. An example is a clothes washer purchased with a rental to buy option, or you've seen those rent to own stores. The seller has to deliver the washer described in the contract. At the time of contracting, there cannot be uncertainty as to which washer or appliance is being sold. The time of delivery should be specified in the contract as well. The dollar amount should be filled in. The exact times of payment need to be covered in the offer. So when you have a secured transaction, that means, for example, somebody's renting to own property. If that transaction is secured, for example, the washer is security for the payment, such that if the customer doesn't pay for the washer, the seller comes and repossesses the appliance. That's what happens under a rent-to-own policy. So usually if you have a secured transaction like that, a rent-to-own an appliance, you need to have a written contract which spells out all of the terms, the time to deliver the goods, time when the installment payments are due, the exact dollar amount that the customer is paying, the amount of interest, so forth. That would be an enforceable agreement. Getting back to the elements of an enforceable offer: price, consideration, and sufficient terms. Imagine Bill wants to be hired by Ron and June to paint their house. All of the terms are oral except for a brief, unsigned bid that is not a complete sentence. Paint Ron and June siding on their house. $1,500 for labor. Homeowners to pay for supplies to be completed this summer. The rest of the terms are oral and include information such as it is a workmanlike job. Bill is to scrape and paint with a primer and finish coat. He must use the paint that Ron and June choose, and Bill also needs to bring his own ladders. So, do you think if the homeowners are not satisfied with the work that Bill does, can they bring an action for breach of contract, Valerie? And could they get their money back?
I don't think they could because if he completed the job, if he got paid, or and he painted the side of the house, and he completed it by the summer, the written contract was fulfilled. If let's say he didn't use the paint that they chose, that would just have to be there would have to be maybe more evidence of that exchange, because he could very well say, I don't remember, or I didn't write it down, I don't remember what you said. And he could just that could be a defense where they wouldn't get their money back, because since it's not written down and there is a written, even though it's incomplete, there is some sort of written contract.
Okay, good. So I'm sure you've watched Judge Judy before in court TV shows. A lot of times people will come into court with, some evidence that's written down, and other evidence is their testimony. If a judge believes a witness's oral testimony in court, that testimony is as good as documentary evidence, if the judge believes that they have a credible witness. And you've seen people like Judge Judy who are really good at reading a person's body language and knowing who's lying. She'll point to one person and say, "You're lying." Judge Judy can tell things like that. So I think, for example, if Bill did not complete the contract in a workmanlike manner, or if Bill did not use the paint that Ron and June chose, they could sue him for breach of contract. If the paint started peeling a month or two later, I think that would be unreasonable. So if they're not satisfied with the job and they can show that a term of the contract has been breached, they could sue for breach of contract. They would simply need to provide evidence to show that the contract was breached, either verbal, written, emails, oral testimony, etc. Good, Valerie. So let's talk about your Module 1 written assignment. In this example, we're going to think about one of the tasks that a paralegal has, which is to interview clients. So, Christy, are you still eating? Let's see if Christy's still eating.
Nope, I am not. I am available.
Okay, great. So do you ever interview clients in your current position with the IP attorney?
Yes, I do.
Okay, what kind of things do you talk about with clients?
I ask them if they've formed an LLC or some kind of a corporation. I I authored a excuse me, an intake form. I collaborated with my supervising attorney and I asked him what he wanted to know about new clients, and I formulated an intake form. So I asked them if they formed some kind of LLC or corporation. I asked them if they have funding, whether it be through government or through investors. I asked them if they have a prototype of their invention, and if they've had any experience with working with an attorney.
Excellent. Those are great questions. So you do use an intake form?
I do. Yes, because I want to make sure that my attorney gets all the information that he needs.
Excellent. Okay, great. So your Module 1 written assignment, which will probably be pretty easy for you, Christy, is asking you a series of questions. The first question, why, in your own words, might an attorney recommend that an oral contract be put in writing, even though we know at common law an oral contract is valid and there are plenty of witnesses to the terms? You can use your Module 1 lesson notes. Comment personally on the transcript of the client interview. How do you feel about the way Helen, the paralegal, did the interview, and what would you change? 2, if you were the paralegal interviewing a client, would you use a printed intake form and mark it with handwriting? Is there another method that you use to make notes? 3, recommend 3 open-ended questions to ask the client at a follow-up interview and 2 questions asking for documents. 4, based on what you know so far, was the oral agreement based on a complete offer or an incomplete offer? Argue both sides based on the lesson notes. Specify any areas of uncertainty. Let me go into the online classroom so we can make sure we have the facts of the case that we're going to be analyzing. Let me share with you a web browser. Okay, can you all see this Microsoft Edge? Going into the online classroom, we're going to take a look at the details of our Module 1 written assignment and the scenario that you'll be analyzing. Can everyone see my desktop, my web browser? We are in spring term 2021. Going under Module 1. Excellent, Christy. Glad you can see it. And we're taking a look at your first written assignment that is due on Sunday. So imagine you are a paralegal. Your name is Helen Davis. You're meeting with a client. The client tells you that Leo, the owner of Riverway Construction of your town, your state, USA, said he would re-roof our one-story house for a lower price than what anyone else bid. So we showed him a bid from Right Fix Construction. He said what they thought was a good bid. He studied it for a while and smiled. And Leo and his crew said that they could do the homeowner's roof for $6,500, which was less than the bid they had previously received from Right Fix. So, however, June, the homeowner says we were not happy with how this work was done. The roof is not exactly what we wanted. The soffits and fascia were not done. Unlike the other contract's written bid, we should have had him do his own bid, but he just started work right away. We were so busy we forgot. So now the client wants to hire your law firm to bring a lawsuit for breach of contract because they are not happy with how the roof was constructed. So you're going to answer these following questions that we just discussed. Number 4, based on what you know so far, was the oral agreement to fix the roof based on a complete or an incomplete offer? Many times in the law, you'll need to be prepared and anticipate the other party's argument. So you'll want to present why you think that it was a complete offer, that the bid was an offer to complete and fix the roof. Then you want to think about what the other side may come at you with and then argue why it was an incomplete bid to fix the roof. And you also want to consider using this application table. So let's take a look at what the application table would look like. Can you see everything now, Valerie?
Yes, I have.
Excellent. We're going to take a look at the application table that you can use when figuring out and analyzing the Module 1 written assignment. Okay, so often when you're working on a legal problem and trying to solve it, it's better to jot some things down and try to look at the issues. So here is an application table that you can fill in that will help you analyze the legal issues, consider what information you might need from your clients, and any relevant law that you can research or look up, citations to statutes and cases. So you'll want to complete this application table. The facts that are given to you is your client is Ron and June Smith. They've hired Leo and Riverway Construction to fix their roof. What more information do you need? What kind of questions do you have for the client? You can fill that in. Any questions about the table? Any questions, Valerie and Christy, about the table?
Nope, I think I'm good.
Okay, so you have the option of using the application table to compare the incomplete and complete offers, identify characteristics of a complete offer. The table will help you apply facts to the assignment scenario to the legal issues and the cited authority. Quote and cite a portion of this week's lecture notes as authority. Your paper should be 3 to 5 pages in length with at least 3 references formatted according to Blue Book standards. So you want to look at the Blue Book. See the rubric for details on how your assignment will be graded. Let me go back into the online classroom and we're going to take a look at the Blue Book. So for all of your assignments in this course, you'll need to do research using Lexis Advance, and then you'll need to cite to reliable references using the Blue Book format. Here we use the Indigo book, which is a manual of legal citation. So Here's what the old-fashioned blue book looks like. But and you may need to use the blue book when you're working as a paralegal. But at Rasmussen University, in this course, we're going to be following the site format for cases and statutes and ethical rules, getting that from the Indigo Blue Book. It's all provided for you online. The first thing we'll look at is a full case citation, because there may already be a case out there about homeowners who contracted to have a roof repair done and they weren't happy and they sued the contractor for breach of contract. And if that case occurred recently in your state, that would be binding precedent. You'd want to know about how that case turned out. So if you were citing a case, here's your example: the party's name, the citation, and in parentheses is the court and the year. That's a standard case citation. That is your Indigo Blue Book site. Here's another one. This is a U.S. Supreme Court case decided in 1953. If you were to pick up a book, volume 346, and turn to page 356, you would find this case, Toulson v. New York Yankees. When referring to a case, after you've given that blue book site, you can refer to it using the parties' names. So the Indigo Blue Book will be a great reference for you. If you're going to start citing to your state statutes, it provides the rules for that too. Alabama Code, section and year. New York Arts and Cultural Law, section and year. You need to cite to the federal rules. Here's the rule for dismissal. Federal Rule of Civil Procedure 12b1 is dismissal for failure to state a claim upon which relief can be granted. So the Indigo Blue Book will show you how to cite to rules. How do you cite to rules, Christy, when you're working at your law firm?
Well, we work with prior art, so the prior art is it is such a horse of a different color. So the prior art is cited so differently. It's cited it's cited according to the U.S. Patent Office's rules. But I have both the Indigo book and the Blue Book, and it's pretty straightforward how to cite for cases and secondary sources. So
Yeah, so you're mostly citing to the Patent Act, right? The patent rules.
the non-patent literature is cited very much according to Blue Book standards, but yeah, like the prior art, U.S. patents and patent applications are kind of very specific to the patent office. But non-patent literature like websites and scientific journal articles and things are very, very close to what the Blue Book requires.
Okay, great. And do you ever cite to anything using the APA format? If it's just a journal, like a scientific journal?
Excuse me, very, very occasionally.
Great.
The patent examiner will cite to a case, and that case will be cited by the Blue Book, but mostly it's federal regulations and statutes, which are cited by Blue Book, but the prior art is usually cited very specifically to the USPTO. But I would say case law and statutes and federal regulations pretty much go by the Blue Book.
Excellent. Great. So, when you click on this link to the Blue Book in this Module 1 assignment, it's also going to connect you with a fast case in case you want to do some research on fast case about contracts. You can do so. Legal documents. There's probably a template here for how to write a brief. And what we're going to be using is a memo, mostly this term. So there's a sample IRAC table. You can download that. How to create a legal memo. I would like you to use this format here for your Module 1 assignment. The to, from, date, and then the line. So you'll want to take a look at the legal memo template. Click here to view a legal memo template. This would be a Word document you can save. Any questions about how to do this Module 1 assignment?
If we so if we use our lesson notes, do we have to cite the lesson notes?
I would cite the lesson notes, yes. And you can use that as one of your 3 references, but you do need 3 references. So the lesson notes can be 1 reference, but those other 2, you're going to need to look on Lexis Advance and find a case. You can cite to a treatise on contracts law, but it would be helpful if you did some research on cases to find out, what the elements are of a valid offer or what a valid bid looks like, what a legally enforceable bid looks like, and see if you can find a case that is similar to the facts of your client's case here concerning their lawsuit over the defective roof replacement job. Any other questions about this Module 1 assignment?
Nope, thank you so much.
Oh, thank you, Valerie, and thank you, Christy, for attending the Module 1 live session. So as it stands now, we will be meeting every Wednesday at 6 p.m. for this live classroom session. We can talk about assignments, we can talk about issues, we can talk about anything you want to. It's your class. This is a great opportunity for you to ask any questions that you have. We'll be using this link. Is this a convenient time for both of you to meet for the live lecture?
Yeah, it's perfect for me. I love it.
Thank you, Christy. We will continue meeting at this time. And if you have any questions or concerns as you're working on your assignments, please feel free to reach out. My e-door is always open to you. I can also direct you to the librarian who can give you assistance doing your research on Lexis Advance. Okay, well, there is no live session question for this week. Next week, there will be a live session question, and the live session will be a graded assignment. So each week you'll have more assignments to do. So appreciate the Module 1 because you only have the 1 memo to write, because the upcoming weeks you're going to have more assignments coming. Well, thank you so much, Valerie and Christy, for your participation. Have a great week.
Thank you. Have a great week.
Bye.
Thank you. Have a good one.
Thank you. I'll see all of you in cyberspace. And if you have not done so already, please be sure to post your introduction into the student lounge so we can get to know everyone. I look forward to working with all of you this term.